the Education Act, Section 19, representation of students. The minister shall cause every public educational institution to keep, in such form and manner as shall be prescribed, a register to be known as the Register of Students, and such register shall contain the prescribed particulars with respect to all persons who are students at that institution. So that's a legal requirement. You must keep a register of students. Section 20. The minister may, by order, declare. So section 20 covers declaration of compulsory education areas and compulsory school age. The minister may by order declare A. Any area within a radius of 3 miles from any school specified in such order to be a compulsory education area, and B. the compulsory school age in relation to such compulsory education. Well, now, any area within a radius of 3 miles as a compulsory education area. I guess that means, probably that means all school age children within that radius must attend that school or some other school. I'm not sure. Any area within a radius of 3 miles from any school specified in such order to be a compulsory education area. Well, understanding that one fully at law at all. If you're an attorney at law, I'm going to ask you to post your comment about that one here. Section 21. Duty of parents to secure education of their children. Right? But remember, if you're an attorney who specializes in this sort of thing, you would have higher level knowledge than other persons. So it would be good to post some explanation of some of these things. Right? All right. To duty of parents here to secure education. That's section 21. Subsection 1 of section 21. It shall be the duty of the parent of every child of compulsory school age residing in a compulsory education area to cause him to receive full-time education suitable to his age and ability and satisfactory to the educational board for the area, either by regular attendance at school or otherwise. Okay. Probably if you do not live within 6 miles from a school, you're not compelled to attend. Is that what it's saying? It seems like what that is saying. If you live 6 miles or less from a school, then you must attend school. But what would imply is that if you live more than 6 miles from a school, then you're not compelled to attend school. Oh no. Well, that seems to be what it is saying. But anyway, so every child must attend school once they live to his age and ability and satisfactory to the educational board for the area. So once the child is of compulsory age residing in a compulsory education area. Alright, subsection 2. If any child of compulsory school age in a compulsory education area who is a registered student of a school fails to attend regularly thereat, the parent of the child shall be guilty of an offense against this section. Now, maybe this act will define what is meant by regularly, or maybe regularly is defined otherwise. But if your child has not attended school regularly, then the school can report you to the police and they take you to court. You are guilty of an offense against this section of the Education Act. 3. In any proceeding for an offense against this section, the child shall not be deemed to have failed to attend regularly at school by reason of his absence therefrom. The child shall not be deemed to have failed to attend school regularly by reason of his absence therefrom. In any proceeding for an offense against this section, the child shall not be deemed to have failed to attend regularly because he was absent. So, if the child is absent, well, it means the child would not have attended. By reason of his absence therefrom. But anyway, that can be clarified. A. At any time when he was prevented from attending by reason of sickness. Okay, so if it is due to sickness or so, then that would not be a reason to say that a child had not attended regularly. A. At any time when he was prevented from attending by reason of sickness or any unavoidable cause. B. With leave granted by any person authorized on the behalf of the owners or board of management of the school. C. If the parent proves that the school at which the child is registered is not within walking distance of the child's home. Okay. But this was written in 1980s and before. So we didn't have much in terms of buses and taxis. But the thing is, we need to, okay, we're going to see what walking distance means now. 4. In this section, walking distance means in relation to any child who has not attained the age of 8 years, 2 miles, and in relation to any other child, 3 miles, measured in each case by the nearest available route. Okay, so this note about the compulsory education radius, it's there in order to cover walking distance. All schools, you didn't have a lot of buses and taxis at the time, and most students would walk. So that seems to be why it talks about a radius of 6 miles in this case. Okay, and that would mean that there must be a school within every 6 miles, or within every 12 miles, since a radius is 6 miles. Which seems to be the case, that there is a school located, generally there is a school located within every 12 miles of a person's home. Alright, subsection 5. Any person who is guilty of an offense against this section shall be liable on summary conviction before a resident magistrate court, in the case of a first conviction, to a fine not exceeding 100 No, not exceeding $1. Okay. In the case of a second conviction, to a fine not exceeding $4. And in the case of a third or subsequent conviction, to a fine not exceeding $10, or to imprisonment for a term not exceeding 14 days, or to such fine and imprisonment. So, if you're a parent and prevents your student from attending school, you have two choices. You pay $1 or spend 14 days in jail. Well, some of these laws are outdated. All right. 6. Where the court before which a prosecution is brought for an offense against this section or section 22 is satisfied that that a child in respect of whom the offense is alleged to have been committed has failed to attend regularly at the school at which he is registered, a registered student, and B, that a person who is alleged to have failed to comply with the requirements of an attendance order is guilty of an offense against section 22. The court may, whether or not the parent is convicted, direct that the child in respect of whom the offense is alleged to have been committed be brought before a children's court by the person or authority by whom or on whose behalf the proceedings were instituted, and the children's court may, if it is satisfied that it is necessary to do so for the purposes of securing the regular attendance of the child at a school, make any order which such a court has power to make under section 80 subsection 2 of the Child Care and Protection Act in the case of children who are brought before it under part 3 of this act. Right. Subsection 7. For the purposes of the Child Care and Protection Act, any child with respect to whom a direction has been given under this section that he be brought before a children's court shall be deemed to be a child about to be brought before such a court under part 3 of this act, and in order any order made by a children's court under this section shall be deemed to be an order made under section 80 part 2 of that act, and all the provisions of that act shall have effect accordingly, but subject to the modification and in relation to any such child. Subsection 1 of section 12 of that act shall have effect as if the words or any person to whom a direction has been given under subsection 6 of section 21 of the Education Act were inserted therein. Next, after the word constable. Subsection 8. In this section and section 22, 23, and 24, any reference to a resident magistrate insofar as it relates A. to a resident magistrate court for the parish of Kingston and for the parish of St. Andrew shall, as respects any time on or after the 13th day of November 1978, be construed as a reference to the family court, corporate area region, and B. to the resident magistrate court for a parish within the geographical jurisdiction of a family court established pursuant to part 3 of the Judicial Family Court Act, shall, as respects any time on or after the date on which such court is established, be construed as a reference to that family court. We will look at section 22 in our next video.